Okay, let's unpack this. Imagine the rugged Australian landscape, potentially holding immense mineral wealth, and picture this becoming the stage for a legal drama, a real clash that goes all the way to the country's highest court. This isn't just some dry legal text we're looking at, it's a story,
Huh.
high stakes, rival ambitions, clever legal moves, and crucially, a fundamental disagreement over how to count days, a disagreement potentially worth millions. Today, we're doing a deep dive into a really fascinating set of sources you've sent us, court judgments, legal analysis, all centered on this pivotal Australian case, Forster v. Jododex, Australia Putty Ltd. And we'll also touch on a related case, Howey and Covey Creative Projects International. It adds another layer, showing just how vital precise timing can be, even in seemingly simpler legal steps. So our mission here is to pull out the most important nuggets from these documents. We want to understand who the players were, follow the twists and turns of this legal fight, and see how it all, well, changed the game for Australian law. It's about getting you informed quickly, finding those aha moments, and really appreciating how incredible precision in legal rules can have these massive real-world consequences.
Yeah, what's truly fascinating here is how these specific disputes, over mining rights, over procedural rules, they actually highlight some really fundamental principles. Principles of statutory interpretation, the role of the courts in clarifying rights, things like that. These cases, especially Forster v. Jododex, give us a crucial insight into how declaratory relief evolved and how courts grapple with the precise meaning of, well, time when it's embedded in legislation and legal documents.
Okay, let's set the scene for the main event. We need to picture the Goulburn district in New South Wales, late 1960s, early 70s, and the prize everyone's after. Valuable minerals, copper, lead, zinc, gold, silver hidden beneath the earth.
Right. So on one side, you've got Jododex, Australia Applied Ltd. They secured exploration license number 220 from the NSW Minister for Mines. That was on 28th November 1968. Now, this wasn't just a permit. It gave them the exclusive right to prospect over a huge area, 102 square miles. And Jododex, they invested considerable sums exploring this land, especially on properties known as Woodlawn, which they actually own, and the Fisher property. They did all this assuming their license was, a secure foundation for everything.
But there was a complication, a shadow maybe, in the form of Anthony Ashley Forster. He had his own sights set on the very same land. And here's the critical part. His move came before Jododex's license was formally granted.
Exactly. On the 7th of November, 1968, so 3 weeks before Jododex got its license, Forster lodged 3 applications with the mining warden. These were for authorities to enter those exact same Woodlawn and Fisher properties to search for similar minerals. Now, it's important to note, Jododex had applied for their exploration license way back March 1967. So you've got Jododex's application coming first, but Forster's applications to enter landing before Jododex's license was actually granted. That chronological overlap, it created a direct conflict over who had priority rights. Big stakes.
And when these competing claims couldn't just be sorted out administratively, the dispute, well, it exploded into full-blown litigation. So let's meet the players in this legal drama.
Okay, the litigants. We have Anthony Ashley Forster, the appellant, seeking that authority to enter the land. Then Jododex Australia Plier Ltd., the first respondent, defending their exploration license. And also involved was the mining warden, the second respondent, the statutory officer initially tasked with looking into Forster's applications.
And the judges. This case worked its way right up the judicial ladder.
Yeah, it started in the Supreme Court of New South Wales in the Equity Division. Justice Street heard it first. He made the initial decision that got appealed. Then the appeal landed right in the High Court of Australia, heard by a full bench of 5 justices: McTiernan, Walsh, Gibbs, Stephen, and Mason J.J. Each one contributed a piece to the complex final judgment, as you'll see.
And who were the legal minds arguing these high stakes?
Right, the legal teams. For the appellant, Anthony Forster, the solicitors were Dawson Waldron. And then before the High Court, Forster had the formidable F.C. Hutley QC appearing for him in reply. Seeing a QC, Queen's Counsel signals the gravity of the case. For Jododex, the first respondent, the solicitors, were Allen and Hemsley, a very well-known firm. And the mining warden, as the second respondent, was represented by the Crown Solicitor for New South Wales, Mr. R.J. McKay. The involvement of these prominent firms and Queen's Counsel really underscores the huge financial implications and the complex legal issues at stake here.
Okay, so the journey from those rival applications to a high court judgment wasn't a straight line. It involved some, let's say, strategic legal maneuvering.
Oh, definitely. The procedural saga began with Forster's applications way back in November '68. Then, for over 2 years, things were quiet. But then, boom, 10th March 1971, the mining warden gives notice he's going to hold an inquiry into Forster's applications on the 26th of March. Jododex, as the owner of Woodlawn and holder of the license, obviously got notice.
So the warden was finally about to step in and potentially decide in Forster's favor, but Jododex made a really bold countermove just days before that inquiry was set to happen.
Precisely. They were facing this imminent warden's inquiry, which could, jeopardize their incredibly valuable rights.
Yeah.
So Jododex, through their solicitors, Allen and Hemsley, launched proceedings in the NSW Supreme Court Equity Division. That was on 22nd June 1971, literally 3 days before the rescheduled warden's hearing on June 25th.
Yeah.
A classic preemptive strike.
What exactly were they asking the court to do? What was the goal here?
They were seeking powerful relief, primarily a declaration from the court, basically asking the court to state definitively that their exploration license had been validly renewed and was still active over the land in question. They also sought an alternative declaration based on their earlier license application. Initially, they even tried for an injunction to stop Forster going before the warden, but they dropped that later. The strategic goal was crystal clear. Get a binding court ruling that would effectively tell the warden, sorry, you can't grant Forster's applications because Jododex has a valid existing license.
And that move led to the first judgment in this saga.
Yes, Justice Street heard the case in the equity court. On 19th November 1971, he found in favor of Jododex. He granted the declaration they wanted that their license was validly renewed. His decision seems influenced by his view that Jododex might not have had a clear right to be heard properly before the warden, or easy remedies if the warden made an error. So court intervention seemed necessary to him.
But Forster didn't stop there. He took the fight right to the top.
That's right. Forster, now with Dawson Waldron as solicitors, and F.C. Hutley QC arguing in reply before the High Court, appealed Street J's decision. Jododex, still represented by Allen and Hemsley, defended the declaration. The Crown's solicitor still represented the warden. The appeal was heard by that full bench of 5 justices in August 1972. Their reserved judgment took time to consider until 1st December 1972.
So what were Forster's main lines of attack on appeal? What was he arguing to the High Court?
He challenged Street J's decision on 3 main grounds. First, jurisdiction. He argued the equity court simply didn't have the power under the relevant Act S10 of the Equity Act to make these kinds of declarations in the first place. He argued the Mining Act created this specific exclusive process through the warden. Second, discretion. Even if there was jurisdiction, he said Street J was wrong to use his discretion to jump in when the warden's process was already underway. And third, the substance. He challenged the actual validity of Jododex's license renewals, arguing they were lodged too late. And the third point had 2 critical parts. First, when did the original license term actually start and end? And second, what did the law mean by applying for renewal not later than 1 month before the expiry? This timing argument, this temporal question, became absolutely central to the whole thing.
Right, so the High Court had to tackle some really fundamental questions, the court's power to get involved at all, and then these very precise questions about counting time. Let's start with the court's power, the jurisdiction issue.
This is where it gets really interesting legally. Forster argued, look, the Mining Act has its own special tribunal, the warden. It even has this clause, S-183, a no certiorari clause, which seemed designed to prevent court review of warden decisions. So he argued the General Equity Court shouldn't have stepped in with a declaration.
But the High Court saw it differently.
Yes, by a majority, they firmly rejected this. Justice Gibbs, especially, gave this detailed historical account of S-10 of the Equity Act. He explained how a 1965 amendment significantly broadened the court's power to make declarations, making it as wide as similar powers in England. He found nothing in the Mining Act that clearly removed this wide jurisdiction. And he noted, importantly, that seeking a declaration wasn't the same as trying to quash the warden's proceedings under that no certiorari clause. It was about clarifying rights beforehand. He also distinguished this case from situations where you challenge a decision already made by a tribunal.
So the High Court effectively said, yes, the Equity Court could step in.
Exactly. They affirmed the jurisdiction was there. Now, Justice Walsh did express significant hesitation. He wasn't sure if Street J should have exercised that discretion, given the pending warden's inquiry. He felt it might undermine the warden. But ultimately, he didn't dissent from dismissing the appeal on that ground. The majority felt that in this case, deciding a pure question of law, the validity of the license based on interpreting the statute was an appropriate use of the court's power, especially given the real live dispute between the parties. This was a significant reinforcement of the superior court's power to declare legal rights and essentially oversee administrative processes. A big deal.
Okay, so the court could hear the case. Then came the fight over time. It started with when the original license actually began. The license was granted for the term of 12 months from the date hereof, and that date was 28th November 1968.
Right. Forster argued from meant including 28th November 1968. So the license would expire at the end of 27 November 1969. Now, if he was right about that, the renewal application made on 28th October 1969 would easily be too late, no matter how you interpreted the 1 month before part.
And the court's view on that starting point.
Unanimous on this. Justices Gibbs, Walsh, Stephen, and Mason all agreed. They said the general rule is that from a specified date usually excludes that date, particularly when you're defining a term, like a lease or a license. They looked at the license, the act, and found nothing to suggest a contrary intention. So the license began at midnight on 28th November 1968 and therefore expired at midnight on 28th November 1969. Justice Mason even pointed to that clause requiring Jododex to immediately commence surveys. He said, look, if the term started on the morning of the 28th, that obligation could arise before the license was even signed later that day. That seemed illogical. They also critically reviewed an older case, Ex parte Turnbull, which had taken an inclusive view and basically said its reasoning wasn't persuasive.
Okay, so the license expired at the very end of 28th November 1969. Got it. Now for the really tricky part. The renewal application had to be made not later than 1 month before the expiry. Jododex applied on 28th October 1969. Was that in time?
This is where the court split 3.2. It all came down to the interpretation and, crucially, the application of the clear days principle.
Clear days. What does that mean in this context?
Well, generally, when a statute or rule requires something to happen, say at least or not less than a certain number of days before an event, it means that many full or clear days must pass between the two events. And this typically involves excluding both the day of the first event, like lodging the application, and the day of the second event, the expiry date when you do the counting. Now, Justices Walsh and Gibbs applied this principle strictly. They said not later than 1 month before. Here means the same as at least one clear month before. So they argued you need a full clear calendar month between the application date, 28th October 69, and the expiry date, 28th November 69. If you exclude both those dates, the calendar month that is truly before 28th November starts on 29th October and ends on 27th November. An application lodged on 28th October 1969 was therefore within that month, not 1 month before, and that required clear sense. So they concluded it was lodged 1 day too late. They leaned heavily on English cases like Carapagnotti v. Comptoir commercial and others dealing with at least or not less than.
So they would have found the renewal invalid?
Yes. They dissented on this point. They would have allowed Forster's appeal, finding the renewals invalid, meaning Jododex's declaration should have been refused.
But the majority saw it differently. How?
Justices Stephen and Mason, they agreed that a clear month was needed, but they applied the principle differently because of a critical detail. The license expired at the very end of the day, at midnight on 28th November 1969. Justice Stephen argued that because the license didn't expire until midnight had passed, the entire day of 28th November 1969 was a whole or clear day that preceded the actual moment of expiry. Therefore, he reasoned, when counting back a clear month, 28th November could be counted as the last day of that clear month. This meant the clear month before expiry started on 29th October. An application on 28th October was therefore before the commencement of this clear month and timely. Justice Mason took a similar tack. He distinguished the Carapagnotti case relied on by the dissenters. He said the event there, commencement of a shipment period, happened at the beginning of the day, justifying excluding that day. But here, the expiry was at the end of the day. He reasoned that because the license didn't expire until the day had fully passed, you couldn't treat the expiry as happening on 28th November in a way that related back to the start of the day for calculation purposes. He referenced some comments by Justice Kiddo in an earlier case, Prowse v. McIntyre, about the end of one day being the start of the next. So for Mason J2, the application of 28th October was made in time.
Wow. So the fate of Jododex's incredibly valuable mining rights literally hinge on a one-day difference in how you apply the clear days rule when something expires at midnight. What was the final verdict then?
By that narrow 3.2 majority, McTiernan, Stephen, and Mason J.J., the High Court, dismissed Forster's appeal. They found that Jododex's application for renewal on 28th October 1969 was made not later than 1 month before the expiry, according to their interpretation. Therefore, the initial renewal and all the subsequent renewals flowing from it were valid.
So for Jododex, this was a massive, massive victory.
Absolutely. It affirmed the validity of their license. It vindicated their significant exploration investments. Their rights over Woodlawn and the Fisher property were secure. And under the Mining Act, the existence of their valid license meant the warden simply couldn't grant Forster's competing applications. Forster's quest for access effectively ended right there.
But even though Forster lost, did the dissenting views, the arguments from Gibbs and Walsh, still matter?
Oh, very much so. While the outcome favored Jododex, the powerful and really detailed reasoning of Justices Gibbs and Walsh on that clear days principle, especially their explanation of excluding both start and end days, provided this significant body of legal analysis that remains influential. Even in dissent, their interpretation contributed substantially to the ongoing common law discussion about interpreting these temporal phrases. It created a precedent where, yes, the decision upheld the renewal, but the detailed debate on the timing rule itself continues to be referenced and wrestled with.
Okay, Forster v. Jododex was clearly a huge case. Substantive rights, judicial power, millions on the line. But sometimes, as you said, even seemingly minor procedural points can sink a case. You mentioned another case, Howey and Co. v. Creative Projects International, that highlights the flip side of this time calculation issue.
Yes, Howey and Co. It was decided in the NSW Supreme Court by Justice Mahoney in 1973, just a bit after the Forster High Court decision. It provides a really practical, almost mundane procedural counterpoint. It wasn't about mining millions, but about the simple yet crucial act of properly serving a legal document within a required time frame.
What was the setup in Howey?
Okay, so Howey & Co. owned some land. Creative Projects International had placed a caveat on it after getting a judgment against Howey. A caveat, basically, is a notice on the title register saying, hold on, I have an interest here, preventing dealings. Howey wanted it gone, arguing Creative Projects didn't have a proper interest to support it. So Howey started proceedings via a summons in the equity court. Their solicitors were Hardings, and their barrister was B.T. Sully. Notably, Creative Projects never showed up in court.
So Howey's trying to get this caveat removed. Creative Projects isn't even appearing. Where did the timing issue come in?
It came down to the court's rules for serving, that summons the document that starts the case. The specific rule required the summons to be served not less than 5 days before the scheduled hearing date. Howey's team served the summons on Creative Projects on Friday, 25th May, 1973. The hearing was set for the following Friday, 1st June, 1973.
That sounds like more than 5 days, doesn't it? Friday to Friday.
But just like in Forster, the rules about calculating time in court proceedings add layers. You have to be precise. Justice Mahoney had to apply not less than 5 days before, in conjunction with other rules. These rules said, when calculating a time period based on a given day or event, like the hearing day, June 1st, you don't count that day. And critically, for a period of 5 days or less, you also have to exclude days when the court registries closed Saturday and Sunday, May 26th and 27th in this instance. So Justice Mahoney ruled that not less than 5 days before meant 5 clear working days. This required excluding the day of service, Friday 25th May, and the day of the hearing, Friday 1st June. And on top of that, because it was a short period, 5 days or less, the intervening Saturday and Sunday also had to be excluded from the count.
Okay, so how did that calculation actually work out? Well, for a hearing on Friday, June 1st, you exclude that day. So the period effectively ends on Thursday, May 31st. Now count back 5 clear working days from Thursday the 31st, skipping the weekend. You get Thursday 31st, Wednesday 30th, Tuesday 29th, Monday 28th. That's only 4 clear working days. To meet the not less than 5 days rule, they needed to have served the summons on or before Thursday 24th May. Service on Friday 25th May only gave those 4 clear working days before the hearing. Insufficient. Justice Mahoney even noted that serving it partway through Friday wouldn't give 5 full days anyway. He found support for this approach in other cases, like Schnabel v. Allard.
And what happened because the service was bad, even with the other side absent?
On the first hearing date, June 1st, Justice Mahoney noticed the defective service. No appearance from Creative Projects, but he refused to make the orders then. He stood the matter over for a week, sent them away to fix it. On the second date, June 8th, still no appearance. He formally ruled the service was insufficient. He couldn't make orders against an absent defendant without proper notice according to the rules. Fair process is key. He then directed Howey's solicitor. Alter the hearing date on the summons to a new date, 22nd June, reserve it properly this time, and adjourn the matter to that new date. Only after, presumably getting proof of proper reservice by June 22nd, was he prepared to actually make the orders removing the caveat. So Howey and Co. is just a really clear demonstration that procedural rules governing notice and time, they aren't optional extras. Failing to follow them meticulously, even if the other side seems to be asleep at the wheel, can cause significant delays and extra costs. It gums up the works.
These two cases then, Forster, the High Court battle over mining billions, and Howey, the Supreme Court case about a procedural deadline, seem miles apart, but they share some common ground, right?
Absolutely. Their connection lies in that shared focus on the absolute primacy of legal text and the rigorous methods courts use to interpret time. Both cases hinged on deciphering the precise meaning of temporal phrases from the date hereof and not later than 1 month before expiry in Forster, not less than 5 days before in Howey.
And that clear days principle is central to both, isn't it?
Yes. In Forster, the application of the clear month principle, particularly how it applied when an event occurs at the very end of a day, that was the source of the deep disagreement among the High Court justices, leading to the split decision. In Howey, Justice Mahoney applied the clear days principle explicitly to procedural rules, showing how it excludes start and end days, and also those non-court days for short periods. It shows the principle is a fundamental tool, used across different levels and types of legal disputes. It's not just some arcane point. Both judgments also underscore the court's role as a kind of guardian. In Forster, protecting substantive legal rights by being willing to make declarations about statutory entitlements even when administrative processes exist. In Howey, protecting procedural fairness by ensuring even an absent party received proper notice according to the rules, making sure the process is fair.
So bringing it all together, what does this mean for Australian legal practice? While Howey clarified a procedural point, Forster v. Jododex seems to have left a much deeper mark.
Well, Forster v. Jododex is considered a landmark case, particularly for its impact on declaratory relief. It powerfully confirmed, and you could argue expanded, the scope of the Superior Court's jurisdiction to grant these binding declarations of right.
How did it expand that exactly?
Well, before Forster, there were perhaps more restrictive views on when declarations could be made. Sometimes they needed a link to traditional equitable rights or other forms of relief. Forster confirmed that under that amended S-10 of the Equity Act, courts had a broad power to declare rights, including rights arising purely from statute, like the validity of Jododex's license. And here's where it gets really interesting again. The court upheld the exercise of this power, even though the Mining Act had that no certiorari clause, aiming to limit judicial review, and had set up its own specialized process before the mining warden. Forster showed that those kinds of provisions wouldn't automatically prevent a court from making a declaration where there was a real question about legal rights. This significantly enhanced the ability of parties to seek judicial clarity on their position, especially in disputes with government bodies or over tricky statutory interpretation. It's still cited constantly as authority for the broad utility of declarations in administrative law.
And what about that intense debate over counting time? Did that leave a legacy?
Yes, absolutely. Forster became a seminal authority on interpreting temporal expressions in statutes, particularly for phrases like at least or not less than X days. Justice gives his detailed explanation, even though it was in dissent on the final outcome regarding time that these generally require X clear days, excluding the start and end days, is still widely cited. Cases even today, like one mentioned in the sources, Hotel Property Investments Ltd. in 2024, reference Forster when grappling with time calculations. Now, they might distinguish it based on the specific statutory context or purpose, especially regarding events happening at the end of a day, but Forster remains a foundational text, even if its application needs careful nuance. So, in mining law specifically, it clarified that the validity of tenements can be determined by superior courts via declarations. That provides a crucial avenue for seeking certainty under complex legislation. In administrative law more broadly, it affirmed the court's role in clarifying legal positions even before a final administrative decision is made, using declarations to potentially preempt unlawful action.
So what does this all mean for you listening in? These cases, from the high-stakes high court battle in Forster to the procedural snag in Howey, they teach us powerful lessons about the law. They show how absolutely critical the precise wording of statutes and rules is, and how arguments over a single day, seemingly tiny details, can determine fortunes and rights.
They also vividly illustrate the judiciary's role meticulously interpreting the text, applying established principles like clear days, ensuring procedural fairness even for absent parties, and ultimately acting as the final arbiter of legal rights, capable of intervening to provide clarity where needed, even in specialized statutory regimes.
It's a reminder that the law isn't static, it's a living thing, with principles being tested and refined in the crucible of specific disputes. The principles affirmed in Forster v. Jododex about declaratory relief and time calculation, they continue to shape legal practice today, influencing everything from complex mining deals right down to the everyday procedures in our courts. So here's a provocative thought for you to maybe mull over. Given how much turned on the interpretation of 1 month before expiry in Forster and how the judges split right down the middle on it, does this kind of precision in legal language provide necessary certainty? Or can it sometimes create an almost arbitrary line between winning and losing, leaving critical outcomes dependent on these incredibly fine points of historical linguistic interpretation? Something to think about. Thanks for diving deep with us into these fascinating cases. We hope you found some valuable nuggets and maybe a few aha moments along the way.